That's correct, Judge.
Yes.
Okay. All right. All right, we are going on the record in the matter of the state of Michigan versus Tamara Whitmer. 25674. Detective, your name for the record, please.
Detective Chelsea Haskin.
All right, I'm going to ask you to please raise your right hand. Do you solemnly swear from the testimony you're about to give this matter to be the truth, the whole truth, and nothing but the truth?
Yeah.
I'm sorry?
I do.
Thank you. And please proceed on the warrant.
On May 14th, 2025 at 2:48 p.m., Wyandotte officers Cox, Barwig, O'Meara, and Perez were dispatched to the area of Fort Street and Eureka Road due to a female sitting in the grass on the side of the road looking out of it. Caller stated the female looked beat up. Upon arrival, Officer Cox spoke with the female, later identified as Tamara Whitmer. Officer Cox observed Whitmer to be highly intoxicated, with extremely slurred speech and an open pint can of MXD margarita sitting beside her. Whitmer was asked about the open alcohol and responded, "Yeah, what are you going to do about it?" Whitmer became disorderly with officers, eventually producing a can of pepper spray from her backpack and pointing it at officers. Whitmer was advised several times to put the pepper spray away. Officers were able to gain control of Whitmer, who sprayed Officer Cox and Barwig on the hands with the back off dog repellent spray. It took several Wyandotte officers to place Whitmer under arrest.
All right. Upon examination, I find the offense charge is committed, probable cause exists to believe defendant committed that offense. And counsel, good morning. Your appearance, please.
Good morning, Judge. Attorney Corey Westmoreland appearing on behalf of Ms. Whitmer. Your Honor, at this time, I did have an opportunity to speak with Ms. Whitmer, and she's electing to waive her right to have counsel represent her at this time.
Okay. Well, okay, Ms. Whitmer, please step forward at the podium. All right, Ms. Whitmer, you do understand that you are in court on criminal charges, correct?
Yes.
And that you do have, and you are here on very serious criminal charges, and that you do have the right to have an attorney represent you at all critical stages of the process. You understand that?
It's exaggeration fraud.
Ma'am?
It's exaggeration fraud.
Excuse me, stop talking. I just asked for a simple yes or no answer. Do you understand that you do have the right to have an attorney represent you at all critical stages of the criminal process?
Yes, I do.
Okay, and that there's a lawyer that's present to represent you. You understand that?
I don't want no,
It's a yes or no answer,
I
ma'am.
don't want the state of Michigan being paid.
Excuse me.
I have
Excuse me.
government corruption reported.
Ms. Whitmer, I am directing you to answer my question, yes or no. You
I said
understand?
no, I do not want him.
That wasn't my question. My question was, you understand that there is an attorney that's here to represent you today. Do you understand that?
I do not want him.
It's yes or no. Do you understand there's an attorney to represent you today?
No, because he shouldn't be there. He told no.
Ma'am, I just wanted you to understand or to indicate whether you
I
understand.
do understand I don't want that attorney. I do not want him.
Stop interrupting me. I just, for the record, want to hear you say that you do or you do not understand that there is an attorney that is here to represent you.
And I don't want him.
Okay, so you do understand that you do have the availability of an attorney.
And I waived it.
Okay, so the court's going to indicate for the record that Ms. Whitmer does understand that there is an attorney that's here to represent her today, and she is choosing to waive that right to representation. Ma'am, I'm not going to ask you about the charges. I'm asking if you want the court to read the charges, or do you want to waive the formal reading of the charges?
You can read the charges.
All right. The court has before it a complaint that alleges on May 14th, 2025, in the area of Fort Street in Eureka, in the city of Wyandotte, that Ms. Whitmer did assault, batter, wound, resist, obstruct, oppose, or endanger Kate Barwig and or Kyle Cox, a police officer in the city with the Wyandotte Police Department, that the defendant knew or had reason to know was performing his duties contrary to MCL 750.81D, paren 1. This is a felony matter. The maximum penalty upon conviction is not more than 2 years in state prison and or $2,000 fine. Consecutive sentence may be imposed under statute if the assault was committed at a place of confinement or under MCL 750.81D6 for another violation arising from the same transaction. Do you understand your charges?
Yes, I do.
All right. For this matter, the court's going to enter a plea of not guilty for purposes of the arraignment. You have the right to have an attorney. If you cannot afford one, the court will appoint one to represent you. And you've chosen to waive your right to representation, correct?
Correct.
All right, the court will note the defendant has waived the right to representation for today's proceedings. However, the court is signing an order for appointment of attorney. In the event you choose to have an attorney moving forward, the court has to sign that. So the court is signing that. And you also have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have a trial by a judge or by a jury. You also have the right to remain silent. Anything you say orally or in writing may be used against you in court. Do you understand those rights?
Yes.
All right. The court's going to schedule this matter for probable cause conference on May 29th
9:45.
at 9:45 a.m. Ma'am, you also have a matter that you failed to appear for back in May of 2024. And so for that matter, we're going to conduct the arraignment on that matter as well. And that's the City of Riverview versus Tamara Whitmer, 24348. And ma'am, you're also waiving your right to an attorney for this matter as well?
Yes.
All right, the court will note that it's alleged that March 31st, 2024, in the area of 17504 4th Street, that you did commit a larceny.
Not guilty.
Ma'am, I'm just informing you of what the charges are and the maximum penalty. Where it's alleged that you took
Not
items,
guilty.
and you took items out of the department washer and dryer area. The maximum penalty upon conviction is not more than 93 days jail and or $500 fine. The complaint also alleges on the same date and location that you did behave in a disorderly fashion in public. That's also a 93-day misdemeanor. The maximum penalty upon, that's also a misdemeanor. The maximum penalty upon conviction is not more than 93 days jail and or a $500 fine. And
I'm pleading not guilty.
I understand that, ma'am. I understand that. The court's going to schedule enter a plea of not guilty.
May I speak?
Excuse me, on your behalf, schedule this matter for pre-trial on June 2nd.
Because it's over the 2 weeks.
So May 19th, Monday. May 19th
At 9:45.
at 9:45 a.m. Ma'am, there's a document for attorney waiver that you're going to need to fill out before you are done today. Now, I also understand, let's talk about bonding now. Where do you live?
I'm homeless.
Okay, and how long have you, been homeless, ma'am?
Off and on since 2020.
Okay, why is that? Are you unable to work?
I'm harassed over a probate case that is already closed since 23.
What do you mean harassed from a probate case?
Harassed, there's a lot of, schemes going on. My attorney, gave us a different personal rep, and she, verified it wasn't canceled. And then someone behind my back and canceled it. There's a lot of, fraud going on.
Okay, and, it's a probate case. Is that because you're a beneficiary of something, or there's a probate case, regarding a petition for your treatment?
No. Treatment for what?
I don't know. I don't know if you have medical issues that you need assistance
No,
with.
no, I don't. I don't like being lied to. I don't like liars.
Okay. All right, well. You previously failed to appear in court here, ma'am. Why is that?
What was that?
You previously failed to appear in court here. Why is that?
I either didn't have a phone or lost contact, didn't know the date and time of the court date.
Okay, well, you also have a failure to appear in 2023 from Southgate. You didn't appear
Right, I'm
in
still homeless.
and resisting an officer.
That was a lie too.
Okay, well, yeah, let me just say this. If you feel as though it's not accurate, you still need to appear in court. Same
Okay,
with the 33rd District Court. You have another charge of resisting, hinder, obstructing an officer, and you did not appear for a show cause hearing in that matter as well.
which one is that regarding?
That's from, so that court is in Woodhaven regarding.
Oh, that was already taken care of. That was already taken care of. So was Southgate.
Okay, and
I repleted, I did police harassment already, discrimination. They're just trying to gain money for the state.
okay, well, ma'am, just so you're aware, if you have.
I know.
You.
But they have that.
Stop interrupting me. Stop interrupting me when I'm talking. Number one, you can't hear what I'm saying. Number two, we're not getting an accurate record. So stop interrupting me when I'm talking. I was telling you, ma'am, that if you choose to have an attorney represent you, there isn't money going to the state for the attorney to represent you. I just want you to be aware of that because you made that comment a number of times.
I would not like an attorney, but thank you.
Are you under the treatment of any medical professional?
No.
Are you currently on probation or parole anywhere, ma'am?
No.
If you were to test, what's in your system?
Just alcohol from the other day, if it's still there. I'm willing to test. I have nothing to hide.
Okay. Then do you have any children that you support or otherwise?
I have a son, he's 22, but he's working and whatnot.
Okay, given the fact that Ms. Whitmer, given a number of factors, number one, the danger to the community, the danger to the officers with the pepper spray possession and discharge, that's been alleged, as well as the failure of Ms. Whitmer to appear in court previously in, the other matters, the court's going to order a $10,000, 10% bond on the 25674 matter. I'm sorry, Detective, would you like to address bond?
No, Your Honor.
As to the 24348 matter, the court's going to set this as a $5,000, 10% bond. These are the following bond conditions, ma'am. You are not to possess any firearms or weapons. That includes any weapons that you are not authorized to carry, such as pepper spray or otherwise. Do you have any weapons, ma'am?
No.
You are not to be connected with Ms.
I have a
Waleed.
pair of scissors, I'm sorry.
I'm sorry?
I cut my own hair, I do have scissors on me.
Where are those?
Those in my backpack.
Okay. And so then the court's going to also order you on the other matter not to have any contact with Natalie Waleed to return to the Huntington Apartments from Riverview. Do you know Ms. Waleed?
What was it called?
Do you know Ms. Waleed?
No.
Okay, then there won't be any problem. You're not to possess or consume any alcohol or drugs that are not prescribed, that's on both matters. And you're not to be released without GPS tether to the Wayne County Jail. And we will see you back on Monday on the one matter and on the 29th on the following matter. Thank you.
Oh, my.
Let's go off the record for a moment.
That was something.
Okay. All right. Jerry, oh,
I mean, we started strong with exaggeration fraud. She looks familiar to me. I think I've seen her on other ones. I have to thank Robin Lee Miller, who tipped me off to that. While we're at it, the first hearing of the day was kind of fun. Why don't we do that since we're here?
City of Melville versus Diane Betts, and the 24th District Court, case number 25OM3700, City of Melville versus Karen Frederick. And appearance for the people, please.
Morning, Your Honor. Evan Zelenak, P27611, attorney for the city of Melvindale.
Thank you.
Oh, yes. We've got a Karen.
And counsel.
Your Honor, Bill Colobus, P38434, on behalf of both defendants.
All right, thank you. And counsel, I'm unfamiliar with any of the circumstances at this point, but is there any conflict in representing both defendants?
No, Your Honor.
Okay.
And I discussed it with both of them.
Okay, and so Ms. Betts?
Yes,
All right, you understand that there's, it appears to be a co-defendant that's named in this matter, and that Mr. Colobus is representing both you and the co-defendant, correct?
that's correct.
All right, and there could be some conflict that arises at some point based upon discovery, but at this point, you are waiving any conflict at this point, correct?
Yes, Your Honor.
Okay, and Ms. Frederick, your name for the record, please. I need you to unmute.
Sorry, Karen Frederick.
All right, thank you. And Ms. Frederick, you heard what I stated to Ms. Betts, correct?
Correct.
And so you're also waiving any potential conflict?
Yeah, I'm good with Clovis for both.
Are they both Karen?
Okay. All right, and so today's the date for the arraignment and pretrial in this matter, and as to the
Oh, good
arraignment.
Lord.
We would stand mute as to both and waive formal reading of the complaint or citation.
All right. All right, the court will waive the formal reading. Enter a plea of not guilty
Thank you.
on each defendant's behalf. And we will schedule this matter for a pretrial. Yeah, I don't know when we're doing that. Let's,
There's videos, Your Honor, police reports, but there's also videos, so I don't know if the court wants to give a little extra time of the next court date or not. And unfortunately, I'm gonna be in a trial all week on a homicide starting Monday, and then June 9th, another case in Jackson for a week, jury trial.
what, I don't know what those dates are, counsel.
Next week is May 19th, so the whole week of May 19th. And then, excuse me, June 9th, that entire week, I'm in Jackson,
All right, somebody get me the video of this
Jackson Circuit.
We could do
government
June 6th.
meeting, please.
Let me know.
That's 2 weeks from, that's 3 weeks from today. Or May 30th.
Get your FOIA
Judge,
skills under
just
control.
on behalf
Oh,
of,
wait, counsel is.
I mean, you're
Just, if I may, just real quick, June 6th, I'm in a jury trial, the Massengale, with Judge in 33rd District Court, Hessen. And that's a firm date with her.
Okay, and so, is it most convenient for both attorneys for a Friday? Is that what we discovered based upon calendars and dockets?
You know, Judge, May 30th, I just have, on 9 o'clock, if you could do it a little bit later in the morning, May 30th, if it's okay for Mr. Zelenak and the court.
I don't think Mr. Zelnick is.
no, I won't be here, but we could find someone to be. I would be in Europe for 2 weeks. I have those Slovak government meetings, Your Honor. And my return date is the 6th.
Could he take all of us there and we could do the arraignment or do the pretrial?
They have no jury rights in that country, so we certainly.
Oh, I think we'll just stay here then. Okay.
Well, let's see here.
Judge, we can get somebody else, whatever day you like. We're not, because I'm certain that there's going to be time to fill the discovery, and I'm speaking on behalf of the city, that there's videotape. I've been instructed chief to cooperate with Mr. Kolovis, given whatever's available, and witness statements, and I don't have them. I don't keep that in my own personal file. So whatever date you like, Judge, and if we have to get someone else here, we will. I just know that turns out that the city attorneys were witnesses or purported witnesses there in the video. That's why I'm here for the city instead. So I can't send one of the city attorneys. We'll.
How about May 30th?
Right.
Does it look like a bad day?
Are you here May 30th, Mr. Zelnick?
No,
Oh, the 30th and the 6th, you have to have.
Yes, right. Those 2 days are bad days.
So May 30th, Mr. Zelenak said he could have somebody cover it.
So we are going to go with 2 weeks from today, because I'm looking at how long this seems to have been pending already. So, we will go with May 30th.
Thank you.
What does our date look like? Shoot.
You can do 9 a.m.
Oh, no, I'm sorry, you have something at 9 a.m.?
Your Honor, what I have at 9 a.m. is Judge White, who's been in the TV lately in Monroe. I have another case with him in front of him. So, Monroe.
I have no idea what you're talking about.
The 2 deaths that occurred in Monroe.
Oh,
That
okay,
was Judge White. He was so happy to see me again on another case.
okay.
But if we could do it maybe at 11 o'clock, that would be fantastic.
Can we do 11 a.m.?
Yes.
Okay, May 30th at 11 a.m.
Again, Your Honor, I can't believe there's nobody in the courtroom. Usually they're lined up to get in.
Well, correct, they sure are.
You've earned that.
Any given Wednesday, so.
You have earned it.
All right, so let's address bond as to both, clients, counsel.
As to both bonding.
Well, first, let's go with Ms. Betts.
Okay, Ms. Betts, doesn't have any criminal history whatsoever, and we would ask for personal bond, Your Honor.
All right, and so Ms. Betts, are you on, you don't have any criminal history according to your attorney, so you're clearly not on probation or parole anywhere, correct?
That's correct, Your Honor.
And you also are not out on bond in any other jurisdiction, are you?
No, Your Honor.
Have you ever had to go to court and fail to appear in court?
No.
Yeah, no Ma Parker here.
What did you say?
See, you're younger.
No, we just
We
said
don't
Bob.
have any type of a Ma Parker.
I thought you said Bob Barker.
I thought you said Bob
That's
Barker.
what I
Ma
thought.
Parker from the 30s.
Okay. Yes, that I don't know, but okay.
It was a
Bob
mobster.
Barker, I know.
It was a mobster. It was a woman mobster, a little older woman mobster known as Ma Barker.
Okay.
I did my history.
Okay, and so, Mr. Zelman, would the people like to address bond?
I just want to advise, yes, Your Honor, that the complaining victim is present. She's a member of City Council. This occurred at City Hall after a council meeting. And the charges may seem minimal as a misdemeanor, but there's a videotape, and Judge Page, who signed the complaint warrant, took testimony and viewed the video before he signed it and thought it was egregious enough to go ahead. Apparently, he does his own probable cause review before a complaint is signed. So we'd ask there be no contact in writing, social media, anything between the parties, because the victim is a sitting council member and it occurred after a council meeting. And I realize that at council meetings, there's name calling and yelling that goes on all the time. It wouldn't be local government if it didn't. But Your Honor, at this time, none of these children are teenagers in a locker room in junior high, and they should act and cooperate, including the instruction to the victim also, don't precipitate any fight. They should not have any contact. They shouldn't shove, jostle, annoy, harass, send emails, anything else to agents, anyone else. I would just ask that because it's a political hotbed. There's other cases that came out of that community too.
Your Honor, how long ago did this happen, the alleged complaint that it happened?
Well, I
I mean,
you would
I
know
don't
that
know if it
because you're
happened
the
a
attorney,
year
and I
ago.
don't, and I've just been, this is the first time I'm seeing all this, so.
I don't know if it happened 6 months or a year ago. So, and there's
Second.
I'm sorry,
Ma'am, please don't interrupt.
there's council meetings the first and third Wednesday where the mayor is extremely good friend and they attend. There hasn't
The
been
mayor's a good friend of whom?
both of them, both defendants, I'm sorry, and political allies. And this is, I believe, political, but that's neither here nor there for me to comment on.
I didn't think I asked for anything out of the ordinary, Judge. This is an assault case. We'd ask for the standard bond conditions on an assault case, and nobody needs to antagonize each other, nor does the victim. So I'm going to tell the victim to keep her trap shut if there's some shouting back and forth. I don't understand where council's going with this, because they should just act like adults and not engage in any
I totally agree.
obnoxious behavior.
I'm just saying that sometimes it could be considered, interpreted as a violation of bond if they're in the same room.
That's why we have a brilliant judge.
This
Your Honor.
is a council meeting that they attend. So they can sit on one side, they can be on the other side, whatever. And there's also an officer in charge of the council meetings, a police officer.
So let me ask this question. Ms. Betts, are you on city council?
No, I'm not.
Okay, you attend the meetings, correct?
I was, but I haven't been since I got served.
Okay, well, probably a good idea as far as keeping, contact to a minimal. Ms. Frederick, are you on city council?
I am not on city council, but I am the chair of Parks and Rec and I'm on planning, so I attend all the council meetings.
And she's
Okay.
the wife of,
Okay.
who are you the wife of?
Of a council member. Council members, Patrick Frederick is my husband.
Her husband's a council member.
Okay. As if it couldn't get any muddier. All right, so,
It's just,
Here's what the court's not going to prohibit the individuals from attending council meetings because, number one, Ms. Frederick, can't be prohibited from attending council meetings at this point, given her position. I mean, unless there's somebody else that could attend, but I also, since October 2nd of 2024, or October 3rd, one of those dates was the date of the offenses, it appears, there have not been any other issues. Would that be accurate, Mr. Zelnok?
That's correct, Your Honor.
Okay.
And it's a public meeting, and it's just,
Correct.
we just want no obnoxious behavior by anyone. I mean, this is not the Andy Griffith Show or Petticoat Junction. They should just try to get along, Your Honor, and I'm sure you recognize those metaphors. These are adults, just behave.
And there's current, the state of Michigan has charges pending against another council person, Joe Jackson, for assault and battery of a secretary that had worked for the city, now quit and has a civil suit actually. And so there's just, in that one is reassigned to 36th District Court Chief Judge McConnell.
It's chaos.
And
Absolute chaos.
So it's almost like, with all due respect, politics, putting the court in between all the politics.
Well, it appears as though nobody really seems to know how to act like adults and how to problem solve and keep their mouths shut. And, I mean, when somebody's saying something that you don't want to hear, right? What we've all learned as kids, turn the other cheek and walk away, and then process it, and then respond appropriately if somebody feels the need to respond. But all of this and the multitude of court involvement in criminal charges, forget court involvement, criminal charges arising from multiple members of city council is incredulous, quite frankly. And I don't even know how everybody even got here. This is my first time knowing any of this. So here's what I'm going to order. That there is not to be any assaultive, threatening, abusive, or intimidating behavior toward Ms. Cartwright.
Behavior in this case is disgusting.
Postings on social media, any form of social media, any print media, any media form whatsoever. It also includes any third party. Now, I'm going to also caveat that because Ms. Frederick's husband's on city council with Ms. Cartwright. And so, since there have not been any issues since October through now, with Ms. Cartwright and Mr. Frederick still serving on the same city council, the court's going to presume that that is actually going relatively okay.
They do. I mean, from what I've seen, I've attended meetings in the past, there's no problem up there on the council. In fact, Mr. Frederick is very a quiet individual, to be honest with you.
Okay. And neither defendant is to appear at Ms. Cartwright's home. Mr. Zelnok, does Ms. Cartwright work outside of city council?
No, she doesn't,
Okay.
Your Honor.
All right, so I was going to indicate her place of employment as well. Are there any questions about any of this court's orders?
No, Your Honor.
No,
Thank you.
The court's going to order a $10,000 personal bond for each defendant with those bond conditions.
Okay, thank you. Judge,
Mr. Zelnok, does your client have any, does Ms. Cartwright have any questions?
No, we're good, Judge. Thank you very much, Your Honor.
Your Honor, I served 12 years on Southgate Council. I retired last year. We've never had any problems, and we're not the model one. I've been to other cities, and you know very well Wyandotte. So it's just things have gotten out of control.
Okay, well, I don't know what's been going on, but I'm going to let everything else, let the discovery and whatnot play out and see what happens. So I'm going to have everybody just have a seat and you'll receive a copy of your bond conditions in just a couple moments, okay?
Okay, you and your staff have a nice weekend.
All right, thank you, you as well.
Thank you,
And
Your
it's
Honor.
in person, the next one is in person, everybody. Ms.
Right.
Frederick, you're in town, correct, on May 30th?
Yes.
Very good, thank you.
Wow. I want this video. I want to see I want to see this council meeting going sideways. Meanwhile, Zach at Law Nerds Unite comes through for me. Everybody told me about the SovCit in Washington this morning. It's all over the place. He got it for me midstream here. Let me see if I can find it. I think I can. Let's do this, people. I have not seen this, but everybody sent it to me, so it must be good. Camera, check. RBF, check.
Good morning. The 14B District Court is now in session. My name is Elaine Washington. And
I find everyone's pain funny but my own. I'm French.
Mr. Fantera, if you, the court will call the case of the Ranches of Rosebrook versus Anais Battle, case number 25C-1245.
Good morning, Your Honor. David Fantera on behalf of the plaintiff.
Battle, please unmute and state your name.
Anais Battle, appearance especially, not generally.
Thank you. All right, we're here for the continuation of the hearing today.
I really need my fez. Okay, it's the same case. I recognize Don Charles. This is continuation. I think I did the last hearing on this. Although the defendant looks different to me. I don't know.
Battle, when you're not speaking.
You said, can I mute my mic when I'm not speaking?
Or is this the one that was calling from her car with all of her kids? That's her. So we couldn't even see her. So, all right.
Correct. Thank you. All right, Mr. Fantera, I believe that we are in the middle of your, well, actually it was Ms. Battles. Direct.
Yeah, I think Ms. Battle was cross-examining Ms. Charles.
That's correct. Ms. Battle, are you ready to proceed?
Yes. So Don, do you have a signed lease between me and you in this case?
Yes.
Did I ever waive my rights or agree to terms in writing?
What's the question?
Did I ever waive any of my rights or agree to your terms in writing?
Your Honor, I object. I have no idea what that means.
Yep.
Meaning that there are waivers inside of the lease.
Okay, well then it calls for a legal conclusion. It's not relevant. She doesn't have the information.
Your Honor, she's got a signed lease. That lease was, we moved to have that admitted last time, and it was admitted. Ms. Battle did not object. So I don't know what she's asking right now when she talks about a waiver. She signed the lease.
Okay, that's fine. Are you aware of the notice of rescission that was sent?
Yes.
I object. Rescission, we can't go down this road again.
Why are we not going down the road?
Let him finish his objection, please.
Okay.
Your Honor, this case is not about rescission. It's about, this is a non-payment of rent, pay and stay case. The question is, how much money does she owe in order to stay in her lease? She believes, and she stated, and she was overruled by Judge Vandenberg, and I believe by you, that her belief that she rescinded her lease and therefore she gets to stay until she finds a new place is not the law, and she should not be allowed to pursue that line of questioning. This is not about rescission, which, by the way, she hasn't done anyway.
All right. So your argument is that her question is not a legal question and therefore you object.
It's not based upon law.
It is based upon, what law is it not based upon? It's based upon common law. You have not proven or stated any laws or facts that back what you're saying. Unlike me, I have.
Yeah, but you stated them all wrong. And one of the things you stated was the Magna Carta, which was from the 12th century in England. Your
No,
Honor,
I stated it under common law
Everyone, please
and
stop.
landlord-tenant acts.
That's not, we're not under common law anymore, ma'am, and that's a part of the problem with sovereign citizens. They think they know the law when they don't. That is
Well,
not.
that sounds prejudiced and biased because I'm not a sovereign citizen. So it seems like you're trying to group me in with them, and that I am not.
Well, whatever you're using as your basis is still not correct. It is not the law.
It is. It's still under
I'm
MCL
not
and it's under the
gonna-
Landlord-Tenant Act.
You are a SovCit, plain and simple. You're saying SovCit things. That's the definition of it. People who believe this nonsense.
Overruled.
my objection is overruled, Your Honor.
No, the objection is sustained. Her question that cannot be asked.
So you're saying I can't ask about the contract that's in question?
No, I'm saying that you have no basis for asking whether the contract was rescinded or not.
Why would I not have basis for asking if the contract was
Because that's
rescinded or
not
not?
the law. You don't get to unilaterally rescind anything, ma'am.
Well, again, as I stated,
My ruling, I'm not arguing with you anymore about it.
right, it's not an argument. So just let the record show that there is no law or basis to what she's saying. And she has not yet stated any law or fact behind this objection.
You have a lease that was entered into evidence, and now it's on you to prove that you've rescinded this somehow unilaterally, which is impossible. You can't do it as a matter of law, but you haven't done anything to suggest that. So you're screwed.
To asking these questions. I will continue. Okay. Did you write me a notice to quit filing this action?
A notice to quit?
Yes.
No.
I think she's referring to a demand for possession,
A
Dawn.
demand for possession, yes.
No, a notice to quit.
No.
Right. Do you have proof of delivery or service of any notice to quit?
No, I didn't send one.
Right. Are you aware that MCL 657-16 requires a notice to quit before initiating an eviction?
Your Honor, I object. Miss Battle is confusing the term notice to quit with demand for possession. A notice to quit is how you start a termination of tenancy case. This case was started with a demand for possession. If Miss Battle wants to use the wrong term, she's going to get the wrong answer. The statute says that we can start a non-payment of rent case with a demand for possession, and that was issued. And if she asked that question, Ms. Charles can answer that question.
Well, if you're gonna, insist on sticking with the law, I suppose.
Is there proof of service? Is there a proof of delivery on that demand for possession?
Miss Battle, can you do me a favor, please, ma'am?
Yeah.
Give me one moment. You studied a statute that I actually need to look up. MCL what?
I'm sorry?
What was the statute that you cited?
MCL 657.6. I mean, not 57.66.
I don't know what happens in this hearing yet because I haven't seen it, and I know probably a lot of you have. But Mr. Fantera deserves a freaking medal for enduring all the continuances on this nonsense. It should have been shut down long ago. It looks like we're headed there today. Hopefully. Judge Washington seems to be out of patience with it, which is good. That's where she should be. And, well, we'll see.
600.5716.
Yeah.
Yeah, have you read that statute?
Yes, I had read it when I first did this.
It uses the term demand for possession.
Okay, everybody please stop talking. It says, a demand for possession or payment shall be in writing, addressed to the person in possession, and shall give the address or other brief description of the premises. It's a demand for possession, not a notice to quit.
Okay, so is there a proof of service of it on the record?
That's a different question, though. So, okay, go ahead.
But that's the question I asked next. Once he said that the
But I
demand for
wanted to
possession.
clarify your question before.
I appreciate it.
All right, Ms. Charles, please add, her question next is there proof?
Do you have a proof of delivery or service for that demand for possession?
Nope.
Nope. Did you know that under MCL that you're required to have a certificate of service or proof of service on the record?
Your Honor, I object. She's now, again, she's not using the statute changed 10 years ago so that you now need on a demand for possession, a certificate of service. And that's what's at the bottom of the page. If she's looking for a proof of service, meaning somebody going to the door, she's going to get the wrong answer again. The term is certificate of service. And I believe Ms. Charles will answer that question differently because there is a certificate of service at the bottom of the demand. So I would appreciate if she's going to cite statutes, she cites them correctly.
Okay. That's fine. I didn't cite an exact statute, but I appreciate your objection.
Yeah, you did. It was wrong, but that's what you were trying to do.
I just said MCL because they're both under NCLs. Both proof of service and certificate of service are both under MCL.
No.
All right, everybody.
You
so can I make my ruling?
Like, let's just okay. All I'm trying to do is ask questions to make sure certain things are on the record. A certificate of service.
Okay.
Judge, you deserve it. She's blatantly in contempt. She just talked over you after you did this. You tolerate it. You've tolerated way too much. That's what happens. Get control of your court.
It's not on the disposition. And just like she read on 657-16, was the property described on that disposition?
Yes.
Was there a description of the property?
Yes.
If there was a description of the property?
Correct.
On my copy, there is no description of the property. But let's continue. Does your company participate in HUD programs or accept federal HUD assistance?
Yes.
Okay. Did you provide me with grievance procedures required by HUD?
Did I provide you with what?
Grievance procedures required by HUD.
Your Honor, I object. That's irrelevant. There are no such grievance procedures under this anything that I'm aware of. I mean, I don't even know what she has a grievance about.
Right. The grievance would be with the breach, and you all have a grievance, and hence on why you initiated a hearing for the breach of the contract. So it goes back to HUD because you're publicly funded, right?
No, we're not.
No, we're not publicly.
Well, you accept HUD housing. You accept HUD housing, and you apply, and you are in compliance with HUD laws and policies, correct?
Yes.
Right. Okay. So if you have HUD terms and you're
Your Honor, I object. Miss Battle is taking.
Object to what? I didn't say anything yet.
Well, I'm objecting because she asked Miss Charles a question, which was, do you get any funding from HUD? Yeah, most companies do. We do. And then she takes that and starts taking that to a next question where it says, well, when you get funding from HUD, and then she's assuming.
I didn't assume anything. I asked the question.
Okay, what was the question you were going to ask?
I said, do you have to follow HUD's policies? That was my next question.
And she said yes.
Right. And then you objected after that.
No, and then you started the next question.
No, I started the question, but I didn't get it out my mouth before you objected me.
Let her ask the next question. And if you have an objection, I can hear it after she finishes her question.
Okay. Are you aware that before you initiate a hearing in court or the administrative process before court, you have to have an administrative
objection? This calls for a legal conclusion. I mean, she's going to state something that's wrong or whatever, but she's asking for a legal conclusion from a lay witness. This is making me insane that this is allowed to go on.
hearing by a HUD administrative judge.
Your Honor, I object. I'm not aware of any.
Say no. I mean, that's
Just
not.
say no because you're not aware, and that's okay to not be aware. That just means that you are not aware of the laws that govern.
No, it doesn't, because
This.
that is not the law, ma'am.
How is it? Okay.
You're making.
Are you aware of the requirement under 42 USC 1437 DK for federally funding or accepted landlords to resolve disputes through HUD before an eviction proceeding?
Your Honor, again, I'm going to object. The fact that Ms. Charles answered the question about having a relationship with HUD doesn't a federally funded property.
I didn't say that you were federally funded. So let's be clear.
Just
I said either federally funded or get federal funds, which you do if you accept Section 8 and vouchers.
No, that's not true.
Why is it not correct? You had to think about it. Yes, it is correct. Because if you receive any type of funds from HUD, which is through Section 8 vouchers or regular vouchers, you get what I'm saying? You receive funding from HUD.
We are. Do you?
I'm not saying
this is all on Judge Washington. We can't have this absolutely insane, back and forth about law. This woman does not know the law. You have, and she's allowing this. He was in the middle of an objection, and then she cuts him off so he can't even make an objection to the question. He needed to be more succinct about it, I suppose, but the judge allowing this, it's insanity. You stop, let him finish his objection, I make a ruling, then you ask an effing question. We don't want to hear your insane ramblings about law, which are all wrong.
I'm not saying that you're funded and that they give you loans of that nature. I am saying that you are within their practice and policies of HUD guidelines because you accept HUD in Section 8.
Your Honor, I object to this whole line of questioning. Ms. Battle does not receive a voucher, and so all of this questioning.
Well, it doesn't matter if I receive a voucher. It matters that you are of that type of entity that needs to go through HUD because you accept those things. So
Your
you
Honor,
agree with those terms and policies of HUD.
Your Honor, she's making that up again.
I'm not making that up. If you're saying that, how am I making it up? It's under 42 USC 1437 DK.
Battle.
It's a federal registrar on it.
Ms. Battle, you've made your record. My ruling is still that every entity that has to file a landlord-tenant action does not have to go through that process to collect rent, ma'am. That is not how it works.
Okay. Okay. You're saying that it doesn't have to, but
okay. The ruling was good, so we got there. But there's no need to let her prattle on for 5 minutes first.
HUD says that these are the requirements, hence why MCL at the bottom is trying to align with HUD guidelines on the same registrar that I'm talking about. You have those codes at the bottom that match up with HUD.
Move on.
Okay. So, well, obviously, if I can't really get a line of questioning, I'm being objected because he feels it's not right. He is objecting with no laws or facts behind anything he's saying. He's just thinking it off the top of his head.
Oh, so you just get to say whatever you want and nobody else can say anything. Imagine an attorney objecting to your inane questions. You're so put upon.
I'm not getting a fair hearing here.
Ms. Battle, move on.
Move on. So, okay. Do you have a copy of the court establishing jurisdiction?
Who's that a question for?
Dawn, my plaintiff.
Your Honor, I object. The court's already said they have jurisdiction over the
The
property.
court said that she had jurisdiction because she said so, and that's non-judicial.
Okay. Ms. Battle, move on.
Move on to what? If I cannot have, this is not a fair hearing. And again, this is why
you're trying to turn this into
I'm not trying to turn it into anything. I'm just trying to state the laws, and I'm not trying to argue with y'all about anything. You get what I'm saying? I'm not trying to argue with y'all. I'm just trying to get y'all to state and prove y'all facts, and y'all have not proven any facts. But for some reason are hindering me in in this proceeding. And
y'all facts for the win. She's just asking questions and looking for y'all facts.
that's why I took this case to the U.S. District Court in Eastern. That's why there's an open case right now with all of you all, because this is just
prepare to lose.
not. And I told the Attorney General, and I told the IRS, and I did everything else, because at the end of the day,
please move
all
on.
of this is not right. And Attorney
I'm
grievances.
going to be filing criminal proceedings against you for all these frivolous things that you're filing against me. So
if you feel that it's frivolous, that's fine, but it's not. My rights and my rights are not frivolous.
Please move on.
It's honestly, if I can't have a fair hearing, nobody has any facts. Y'all talked about constructive possession. Nobody wants to talk about that. Y'all keep saying that I rescinded a contract unilaterally. That's not the case. It's called notice.
Ask a question. This is not argument time. Ask a question. If it's objected to and sustained, then ask a different question. Those are the only options available to you. She only doesn't understand this because we're not applying the law to her. You can't blame her for going on like a crazy lunatic. It's working. She's gotten 17 continuances this way, and no one stops her.
And when a notice goes unrebutted, just like if I was to come here, if I was to get that notice of dispossession and get a notice of a hearing, and I missed that hearing because I did not rebut, that would constitute as
cross-examination. If you're not going to ask appropriate questions, then I'm just going to silence you. So you get the opportunity to ask your questions, or you can just be silenced.
I don't have a real opportunity to ask the questions.
Finally, thank you, Judge Washington. About 20 minutes later than it needed to be, but we got there.
So at this point, like I said, I'm just going to have to get the federal court involved and get the marshals, because I don't know what you all are going to do.
Federal court, come on. What sort of amateur are you? You need to go straight to the head with this.
You all have not been acting in honor and with good faith. So I don't know. I'm stuck on what to do. The integrity of the court is questioned.
With you. I don't know what that is, but you should seek some mental health, because something's wrong with you. You have a mental problem.
I have a mental problem. How?
The United States don't apply to you, and you get to make them up as you go along, like you know more than everybody else in the world. There's clearly something wrong with you.
No. What did I make up?
All of it.
What? Be specific. No, be specific, because now you're lying on the record. This is perjury. I didn't make nothing up. 42 USC definitely applies to this case.
All right.
Jurisdiction is a threshold.
Ma'am, if you don't stop, I'm going to remove you from the court proceeding.
Look at her
Mr. Fantera, apparently we're not going to have a reasonable hearing here today, because Ms. Battle feels as though the laws are very different for her as opposed to everybody else in the world. I'm not certain how to handle this going forward. You have submitted your documentation, and she wants to argue stuff that's not law, regardless of my rulings. So therefore, I'm not sure what to do with respect to your case.
I would ask for a directed verdict. She hasn't said anything that is a defense to my action, and I submitted a proposed judgment this morning. There's rent owing in the amount of $3,432.42, court costs of $177 for a total of $3609.42. We would ask for a judgment for possession with a writ after 10 days, and she can avail herself of whatever procedures she can.
Yes, judgment for the plaintiff. They've made their case. She has not asserted a defense or held a coherent sentence. She loses. This isn't difficult.
In another court.
So you're saying that none of my objections is valid towards your claim. So having a valid contract is not an objection. Oh, because you're saying that because a notice was given and unrebutted, it's not of law. That's what you're saying, right?
Yes, that's not the law.
It is. It's the law. It's Wells versus Zendaya of Michigan. It is. It's
all right.
It's
Um,
backed in case law, and y'all keep muting
ma'am,
me. It's okay. Because he can talk, but I can't talk.
ma'am, you've argued that over and over, and I've ruled that it's not. You can file your appeals, file all the things you're filing, but when you file false liens against people, that is a crime.
It's not a false lien. You got defaulted on a private side, and you know that.
Okay, whatever. All right,
Yeah,
so
okay.
what I'm going to do is grant your judgment in this particular case. Her an opportunity to present defenses that are real, and she has refused to do that.
I didn't refuse to present defenses. You didn't ask me about my piece of the case. I only got to cross-examine. You didn't ask me about my defenses.
What are your defenses, ma'am? And rescission is not one. I've ruled that it's not.
I'm sorry?
I know you heard me.
No, I didn't. You said, what are your defenses? And I didn't hear the
ruled
last
that
piece.
your rescission is not a defense.
Okay, that's fine.
That is your defense.
Right, because, you know, threshold matters are not an issue. But again, like I said, the fundamental objections and a counterclaim, object to the subject matter jurisdiction. You all accept and receive housing funds, making the subject
We're
matter.
going down the same road.
Okay, listen, stop. I didn't cut you
stop.
off. I didn't cut you off. You just asked
not.
me what my defense was. And
All right, I'm done.
wow. You're asking me what my defense is. I can't.
Take her out. I've asked her 3 times to stop this. All right, I'm going to grant your judgment in this particular case.
Your Honor, are you going to check the box after hearing?
Yes.
Thank you.
Thank you.
I'm sorry.
Thank you, Judge Washington.
I'm sorry you had to go through that.
All right, thank you.
Thanks.
Appreciate it. Bye.
Bye.
Well, sorry about that. I had housekeeping all over me again. Well, we finally got there. But it's okay. It's not tragic. She finally got there, but she let it go on too long. And she let the record get ugly for no reason. When you have someone who's like that, you have to stay right on them. Because that's all they do. That's all their thing. Just misstate the law, ask things, argue instead of ask questions. This isn't surprising. A judge who's been through a lot of hearings, and she has, knows what pro se, SovCits, or just vexatious litigants, or even just attorneys operating in bad faith, what they do, or people who don't know what they're doing. And you have to know how to control that. And she just doesn't. She gets to the right conclusion. But we're making this ugly record. And meanwhile, these people have been deprived of their property for multiple continuances for someone who doesn't pay and whose position is, I get to stay here for free. It's maddening. But we did get to see her this time. That was fun. Oh, I just want, this all started because that first one with the what is that? Exaggeration fraud. And then they just kept coming. But thanks, Law Nerds Unite. Sent that over to me midstream. I hadn't seen 1 second of it. I remember I did the last hearing, except she called in and she had her kids screaming the whole time. And we couldn't see her. So this time we got to see her. She does not look like I imagined she would look. Not that matters. I'm just saying she didn't look like I thought she would look. She looks nice. She looks the soft. That's not her problem. She's not an ugly person or something physically. Her attitude is ugly. Her grasp of the English language is tenuous at best. All that's a scam. She knows it. She just wants to stay somewhere for free. You give for the purpose of the record, you give them an opportunity to present their case, their defense. They have to follow the rules while they're doing it. If they don't follow the rules and can't ask questions, for instance, while someone's testifying or whatever, then they give up their right to continue with the witness. Then you ask, do you have any other witnesses? I mean, that's sort of the procedure here turned out very sloppy. We got to the right thing. She's a scammer who just is trying to continue, and she got multiple continuances. But my whole thing is ask a question, stop making legal arguments. If she makes another legal argument, okay, you're done. You don't get to ask this witness any more questions. Do you have another witness or any other evidence you'd like to present? No? Okay, then do you rest? Yes? All right, judgment for the plaintiff. That's how this is done. Or so I've heard. I don't know. I don't know why I would have an opinion on such a topic. But that was wild. She was out there, and the first one was a hoot. The first one was a hoot, and then sandwiched in there we had Grandma Karen, literally Karen. Special thanks to Lone Wolf and Colin for that. All right, thank you, Zach. Thank you. All right. So it looks like Zach got it to me, and it looks like he had help. Very, very cool. Big shout out to Lone Wolf and Colin and Law Nerds Unite. That was fun. This turned into a much longer stream than I thought. Wyandotte Thunderdome. Judge Washington is not a stupid person. She gets to where she needs to be, but she is too indulgent and she doesn't see the problems that cause. She has a blind spot. She has a blind spot. She allows too much, not sticking to the procedure, leans for some people, not all people, but some people, and then it blows up in her face every time. Look, I'm not perfect or whatever, but I'm sitting there watching her sober as a deacon, you know, with no pressure on me, and I can see what the problems are. She's generally okay, but you can't let this circus develop. And it's one thing if you have a hearing and then it goes sideways over time. That can happen to any judge or anybody. But when you have a SovCit and a woman who's done nothing but be malignant from the beginning, you've got to have a game plan going into the hearing. We are going to keep this on the road. That's it. I'm not out to get you, but you are going to follow the procedure or we're cutting it off. That has got to be your mindset going into the hearing or you get chaos. Period. End of statement. You don't know. There's due process. So she's trying this rescission. That's nonsense. Maybe she's got another defense that she didn't mention. I highly doubt it or whatever, but maybe she's got something legitimate. You have to allow her to maybe stumble into something worth talking about. She didn't the entire time. But it is a hearing. She does get to express herself, but you know, she presents a rescission defense. Okay, that's a loser. I've ruled against it. Next, do you have anything else? Yes or no? Yes, let's hear it. Oh, it's more nonsense. I'm ruling against that. Do you have anything else? No? All right, you lose. As a matter of law, they've established a lease. You've established no defense. Judgment plaintiff. Done. Okay. I talk law, but that was mostly therapy for me, and it was after the video. So don't be mad at me. All right, thank y'all for coming out. That was a lot of fun and a lot longer than I anticipated, but good stuff. I will see